Welcome back to the channel. I am Ronald Onyango, a solicitor and migration consultant, and this is part 2 of our discussion series on how overstayers in the UK can legally regularize their status. If you haven't watched part 1, I highly recommend checking it out, as I have covered 5 important ways which may be able to apply for residency. Just to recap briefly, this was as follows: parents of a British settled person, partner of a qualifying child's parents, private life application based on 20-year rule, and a private life application based on a 7-year rule for a qualifying child. And lastly, significant obstacles to integration in your home country. I recommend that you go and watch part 1, where I provide some insights in depth of these 5 listed above. In this particular video, I'll share 5 more options that could help you stay in the UK legally as an overstayer. Let's get started. The first one is as a domestic abuse victim. Under this route, if you were in the UK on a spouse visa or a visa as a dependent of a settled person and you suffered domestic abuse, you may be eligible to apply for indefinite leave to remain. This route is open to victims of physical, emotional, financial, psychological abuse. One must provide evidence such as the police reports, medical records, or statements from supporting organizations. If this is approved, you can then stay in the UK permanently without needing a sponsor. The UK government takes domestic abuse cases seriously, so it is important to seek legal advice immediately if this applies to you. The second one is marriage or civil partnership with a UK citizen or a settled person. If you are in a genuine and subsisting relationship with a British settled person or someone with indefinite leave to remain, you can then proceed to apply for a family visa based on your relationship. In this route, you'll be required to prove that your relationship is real and ongoing, known as subsisting. You and your partner must also meet the financial requirement of £29,000 per year, which increased since 11th of April 2024 through employment income. If you do not meet this amount through employment income, you can however prove it via savings of 88,500 on self-employed person profits, pension rental income, verified dividends, and the rest. You may need to prove that it would be unreasonable for you to leave the UK and apply from your home country. If approved, you'll be granted leave to remain and can apply for settled status after a qualifying period. The third route is as a long residence under the 10-year rule. If you've lived in the UK lawfully for 10 years, even with visa gaps or overstaying periods, you may be able to apply for indefinite leave to remain based on long residence. You must in this case prove continuous residence for at least 10 years. Short periods of overstaying may be excused, however, you must show how you have kept legal status most of the time. You must also meet the English language requirement and character requirement. This is a strong route for those who have spent a significant proportion of their life in the UK and have established social, educational or work ties in the UK. And the fourth route is a private life, significant obstacles to integration. If returning to your home country would cause you serious hardship, you may be able to stay under the private life. This route applies if you don't meet the 20-year rule, but have lived in the UK long enough to face difficulties of reintegration, but must prove that you lack family ties, language skills, or access to basic services in your own home country. Health issues, discrimination, or political instability in your home country may also strengthen your case. This is a high threshold application, but with strong evidence, you may be granted leave to remain. The fifth option is armed forces connection. A partner of a child of a British Army member. If you are the partner, spouse of a child of someone serving in the British Army forces, you may qualify for settlement in the UK. You must be in a genuine relationship with the serving member. Your partner must have been in the British Army, the Royal Navy, Air Force. This route provides indefinite leave to remain for family members. The UK usually values those who serve in the armed forces and their families, and are often given favorable immigration options. In conclusion, these are the 5 ways overstayers can legally remain in the UK. If you haven't watched part 1, check it out and learn the 5 methods which I mentioned before. Immigration rules can be complex and each case is unique. If any of the options apply to you, seek professional legal advice as soon as possible. I hope you found the explanations of the 5 ways which an overstayer can legally stay in the UK. I've given insights, some of which were in the part 1 section, and I've mentioned the second part section, which gives you an overall of 10 ways which an overstayer can legally be able to stay in the UK. These are usually options available to those who've run out of options and are struggling to find ways in which they can legally be in the UK. I hope that they found them useful, and if there are any areas which they need clarifications, I'll be happy to expound further. I am Ronald Onyango, and I specialize in UK immigration law and consultancy. If anyone needs help, book a consultation using the link which is below my page. For more immigration updates, subscribe to the channel, hit the like button, and share this video with others who may need this information just like you do. See you in the next video where I'll be sharing more insights, various other immigration topics. Thank you for joining.